Winning a case but not recovering the money. Why? Hello, I'm Tani, the virtual assistant of BLawyers Vietnam. Imagine this situation. Your business has delivered the goods, provided the services, and fulfilled its contractual obligations. But the other party delays payment, avoids responsibility, or even terminates the contract without prior notice. At that point, the question is not only, who is right and who is wrong? The more important question is, what should the business do to protect its interests in practice? In a commercial dispute in Vietnam, there are 3 issues that businesses should not underestimate. First, court or arbitration. This is not just a minor clause in a contract. A dispute resolution clause can affect the speed of the proceedings, the cost of pursuing the dispute, the confidentiality of business information, and even the company's negotiation strategy. Court proceedings may involve lower filing fees and several levels of review. But they can also take longer, and court hearings and judgments are generally public. Commercial arbitration, such as proceedings before VIAC, is often chosen for confidentiality and speed. However, arbitration fees are usually higher, and an arbitral award is final and binding, which means there are very limited opportunities to have the outcome reviewed. The key point is this: if a contract refers to both court and arbitration, or if the dispute resolution clause is unclear, the business may face a separate dispute before it even reaches the main dispute. In other words, a dispute resolution clause is not a boilerplate clause. It is a business risk management tool. Second, is an 8% penalty enough to protect the business? Many businesses confuse a penalty for breach with late payment interest. Legally speaking, these are 2 different concepts. A penalty for breach is a sanction applied when a party breaches its contractual obligations. In commercial contracts, the penalty is generally capped at 8% of the value of the breached portion of the obligation, except in certain special cases provided by law. Late payment interest, on the other hand, compensates for the delay in paying for goods, services, or other amounts due. If this clause is not drafted clearly, the business may face difficulties when claiming interest during the dispute and at the enforcement stage. A good contract should not only help a business win the legal argument. It should also improve the business's ability to recover what it is entitled to in practice. Third, after winning the case, how can the business actually recover the money? In practice, some businesses win a case and obtain a judgment or an arbitral award, but still face difficulties at the enforcement stage. For example, the judgment debtor may no longer have assets, or may have deliberately dissipated its assets. That is why, from the early stage of a dispute, a business should assess not only the likelihood of winning, but also the likelihood of recovery, the time involved, the cost, and the impact on the long-term business relationship with the counterparty. At BLawyers Vietnam, we usually begin by reviewing the full case file, sending a demand letter where appropriate, supporting negotiation, and building a litigation or arbitration strategy linked to the client's practical recovery objective. In a commercial dispute, winning legally is important. But winning commercially is the ultimate objective. If your business is reviewing a contract or preparing for a commercial dispute, start with 03 questions: court or arbitration? Are the penalty and late payment interest clauses clear enough? And what is the recovery strategy after the dispute? This content is for general informational purposes only and should not be considered legal advice for any specific matter. I'm Tani, the virtual assistant of BLawyers Vietnam. If you found this useful, leave a comment,